Prosecutors in the Eastern District of Virginia may have an uphill battle ahead of them after former FBI Director James Comey pleaded not guilty to their charges, as we expected him to, alleging he lied to Congress. And so far, the wheels seem to have already started coming off. I mean, at one point today, Comey's attorney, Patrick Fitzgerald, says he didn't receive a draft of a key discovery order from prosecutors until 11 p.m. last night, with Fitzgerald adding, "I confess, I was asleep." And then there's the star of the prosecution show, interim U.S. Attorney Lindsay Halligan. Let me read to you everything she said in today's hearing. I'll read you the whole thing. Lindsay Halligan. That's it. She said her own name at the start of the hearing and then nothing else. Nailed it. Crushed it. Joining us now to talk about all of this is Preet Bharara, former U.S. Attorney for the Southern District of New York. Preet, so much is happening at the same time, and I want to ask you about the big picture here, but I just want to start with a couple of things about today and the specifics of what's happening with Comey and the path forward. I mean, his defense attorney said he plans to file... Oh, great to see you, too. His defense attorney said he plans to file motions both for vindictive prosecution and to disqualify Lindsay Halligan's appointment as U.S. Attorney. Help us understand what the path is for those, how likely they are to succeed. What does it look like? What should we understand about it?
Yeah, so these are motions that almost never succeed. The history of these, excuse me, the history of these motions' success historically is very, very low. But they're available in extreme circumstances. And I think a lot of people would say that if there were ever a circumstance in which they might work, it might be this one. And we have a precedent for it already. In a completely different context, in a completely different case, the case of Mr. Abrego Garcia that people may be familiar with, there was a motion made by defense counsel, not for outright dismissal on these grounds, but to get discovery and to get more information to learn whether or not the prosecution was brought not in good faith because a crime was committed, but to punish or to be punitive towards a defendant who was exercising his rights. And that motion was granted for discovery. So here, you have a long record of the President of the United States who claims to be a part of the unitary executive, who says that he has every right to direct prosecutors under him, including the Attorney General of the United States, to investigate and prosecute and imprison people who he doesn't like if he wants to. There's a long record of him saying that he doesn't like Jim Comey, saying that Jim Comey is a traitor, saying that Jim Comey should be in prison. And if the answer to those questions is that the defense lawyers will ask, is that the reason why the case was brought, vindictively and maliciously? Well, that's a basis to dismiss the indictment altogether. And that motion, I think, is going to be quite strong based on the evidence we have so far.
Do you think, well, let me ask you about one specific thing that broke just right before the show, because, and this isn't really a surprise. I mean, the Truth Social post where Donald Trump is sort of directing Pam Bondi to go after Comey, saying nothing is being done, what about Comey? It turns out was meant to be a direct message. Does that matter in terms of from the legal? So how does it matter? Help us understand that.
So I think that's a big problem, legally and substantively. For the Department of Justice and for the president. As we said, not just Jim Comey, not just Mr. Abrego Garcia, but other people who are in the crosshairs of the president, various elected members that have been talked about on this show, will have viable motions to dismiss indictments if they come in the future on the basis of vindictiveness. And to the extent that there are public statements that we have heard about, that's powerful evidence. But if it's the case that this message that you're describing was meant to be a direct message, a private message, I will bet you everything that I have that that wasn't the only one. That there's a course of dealing, there's a course of correspondence between the President of the United States, the Attorney General, maybe other people in the Department of Justice, maybe individual U.S. attorneys and other cabinet officials that will bear light on the question of the vindictiveness of the prosecution. And so if you get those things in discovery, which I think at a minimum will be granted in the Comey case, as it was granted in the Abrego Garcia case, that's very, very bad for the prosecution. On the other hand, even worse perhaps, if those communications took place but were not preserved, and hypothetically, I think good lawyers will have already asked for those communications to have been preserved in anticipation of this litigation. If they have not been, if they have been destroyed, that is a terrible look for the president and the people who work for him. And it also gives rise to an adverse inference about what's in those communications. And there is an argument that those communications and the destruction thereof by themselves are a basis to dismiss an indictment.
That's such an interesting point, and I hadn't thought of that. I mean, the DMs, there's no way this was the only DM, just like it wasn't the only signal chat among national security officials. And so if you're the lawyers or any good reporter, you're looking for that information for different reasons. Do you think, I mean, this is supposed to go to trial in January. Do you think it gets there?
I don't think it gets there. And there's a part of Jim Comey, based on what he said in his Instagram post, that wants to have a trial. He said, let's have a trial. But there have been so many errors. There's so much evidence of vindictiveness and selective prosecution and other problems that I don't think it gets to trial. By the way, we were talking earlier about how some of these new prosecutors, may not be well versed in the case. It's hard to blame. It's hard to blame them for that because they're new to the case. On the other hand, so that's on one hand. On the other hand, you kind of wonder how it can be that new prosecutors, knowing that very, very seasoned, experienced prosecutors who were on the ground level of the investigation, who looked at the facts, who interviewed witnesses, who looked at documents, and were well-versed in the case, thought it should not go forward. So to decide to go forward and insert yourself from another district, in this case, not knowing all the facts is odd to me, and we'll see how that plays out.
Preet Bharara, thank you, as always, for giving us a lot to think about. Better understanding of the law without a law degree, as always. Thank you again.
And we are following what it looks like when Donald Trump calls in an indictment, which he publicly did, a Nixonian admission that he wanted someone he opposes or doesn't like to be charged, James Comey. That individual has been charged, and today it turns to court. It's really happening. The former FBI director appeared in court for the first time since the DOJ indictment. So this is the beginning of the case. This is the beginning, if you will, of the process that leads to a trial if the case holds and isn't tossed before then. He pled not guilty today to the charges of lying to Congress back in 2020 around issues that stem all the way back to Trump's first term. It's a pivotal moment in how this DOJ has continued to bend to things that we know from the public record its own prosecutors and internal staff appointed by Trump thought were wrong, bending to things that they didn't want to do, sometimes having to change staff, Trump ousting the prosecutor there in order to get what he sees as his revenge indictments. Now, Comey's long been the subject of clashing with Trump, all the way back to how he did what he and others saw as his job. And remember, these issues have long already been investigated. They've been reviewed by the DOJ's internal process. They were reviewed by a prosecutor handpicked by Trump, John Durham, and other reviews. None of this, whatever one thinks of it, has ever been seen by any other prior process to involve any misconduct of a criminal nature by James Comey. And yet that is what Trump demanded be charged and what got charged. So we take a look back at a history that goes all the way to Trump's first presidential campaign.
The FBI director told Congress he is investigating
whether there was any coordination between people associated with the Trump campaign and the Russians.
The FBI, James Comey, has been fired.
Look, I've seen the tweet about tapes. Lordy, I hope they're tapes. Led to the indictment of dozens of people. The head of Trump's campaign was a grave counterintelligence threat.
Former CIA Director John Brennan and former FBI Director James Comey are under criminal investigation.
In the Trump era, I've been investigated a lot, audited a lot, and so it's not my first rodeo.
Former FBI Director James Comey has just been indicted on 2 counts.
There are costs to standing up to Donald Trump, but we couldn't imagine ourselves living any other way. We will not live on our knees.
The last statement there was Comey's video presentation, a kind of video public accounting for what he says are the costs of opposing Donald Trump. And let's call it like it is. Let's be straight. James Comey has been controversial on the left, right, and center for a bunch of stuff. But nobody who honestly has reviewed him or criticized him, and he has been criticized for his leadership, for his approach to the FBI on this and other newscasts. But nobody who seriously looked at this thought there were crimes there. Remember, there's no new evidence that we've seen yet. If they have new criminal evidence, we'll report on it. But all of this goes back to him testifying to Congress about prior activities regarding talking to the press, press releases, press leaks, right? An authorized statement versus a leak. But none of that has ever led, as I remind you, to anything that anyone thought was a crime, including Donald Trump's hand-picked prosecutor, John Durham. So it's important to keep that in mind, because whatever Comey's popularity, all of the evidence that we have in public suggests this is the old stuff that even Trump's people didn't think amounted to evidence to charge, that now is being charged because the president phoned it in, possibly unlawfully, possibly illegally. The indictment related to that history was not brought in the normal course by the normal prosecutor. One prosecutor ousted, another brought in, and before she had what any lawyer would tell you is enough time to go through the facts and the evidence and the case and the witnesses, she just rushed in for a deadline and charged it. And no one else would sign their name next to what she put. The Times reports 2 prosecutors in North Carolina now been assigned to the case because she had, quote, a hard time getting anyone in her new office to help. Think about what the Times is reporting. Her new office is in the Trump administration. These are all Trump people, but many of them say it's not a real case. You might violate your legal duties to pursue it, or they don't want to be a part of a clunker that could turn into a loser. She did not speak in court today. She was reportedly in her chair nodding when a junior prosecutor represented the department. She was the only prosecutor to sign the indictment. I'm going to remind you of that, like I said there. And the indictment itself doesn't have a lot of evidence. It's 2 pages. It's about congressional testimony. Comey's team is out there going on offense today, and with all due respect, they have a legal team, several DOJ lawyers with far more experience than the new prosecutor that Trump called in. They say they haven't even been given real specifics on the charges, that they are going at the whole case, seeking its dismissal, and they're going to use Trump's words against him, saying that they have evidence to prove, and these aren't just any random defense lawyers. These are some very skilled, decorated DOJ veterans, one who worked as a Republican, Fitzgerald, investigating high-level matters. They say they can prove, they think, that it's a, quote, vindictive and selective prosecution. They also say this new hand-picked prosecutor might have problems of validity. The government doesn't have a lot of details, but they claim they need more time to introduce what they call classified evidence. The judge already, on this first day leading to the trial, quote, skeptical of the claim that the nature of this, remember, we're talking about public testimony about issues that have been discussed for years. If this weren't so important, some people might say, I'm a little tired of stories about the Clintons and James Comey. But of course, this is Trump's revenge tour. This is what he wants everyone to focus on. And the judge is skeptical that there's going to be new classified evidence. The Times said it kind of projected an air of polite impatience on the first day of Trump team's effort to prosecute the former FBI director. Quote, this does not appear to me to be an overly complicated case, the judge added. Again, striking at the obvious. There isn't a ton of new evidence against the director. What there is old evidence that was previously dismissed, found lacking by perfectly motivated Trump appointees who, had they had the case before, would have presumably been willing to bring it. Indeed, they take an oath to bring cases that are supported by the evidence. Now, a new prosecutor, lonely in her office, doing Trump's bidding, and today seemingly outgunned by some of the more experienced counsel against her, is going to try to take the director to trial.
Let me ask you something. When power wants revenge, do we still have a justice system or just a stage show with handcuffs? Because what we saw today didn't look like fairness. It looked like a rush job stitched together with ego and fear. Here's the setup. Former FBI Director James Comey pleaded not guilty to charges that he lied to Congress. That alone is explosive. But then we learned the government sent a key discovery draft to the defense around 11 p.m., hours before court. And the interim U.S. attorney supposedly leading this thing, she introduced herself and said nothing else. That's not confidence. That's a red flag waving over a courtroom. Now, Comey's team is moving to argue vindictive prosecution. The idea that this case isn't about law, it's about payback. That's a rare motion. It almost never wins. But this time, there's smoke, maybe fire. Because we don't just have public bluster about jailing enemies. We have reports of direct messages, private nudges from the top to go after specific people. If that's true, it's not just bad optics. It screams intent. And if the intent is to punish a critic, not to prosecute a crime, the indictment rots from the inside. Here's why this matters beyond one defendant. A president who treats prosecutors like personal bodyguards can aim the state's most powerful weapons, subpoenas, raids, trials, at anyone who crosses him. That's how democracies corrode. Not overnight, not with tanks, but with case-by-case exceptions that become the new normal. And when the files and the messages around those decisions mysteriously vanish, you don't just lose evidence, you lose public faith. And look at the mechanics here. You parachute in new lawyers who barely know the record. You scramble filings at midnight. You hope the spectacle, cameras, headlines, the word indicted, does the job that facts can't. It's performance prosecution. It's reality TV with real consequences for the people in the dock and for the rule book that keeps the rest of us safe from arbitrary power. The moral core is simple. If the state can target the loudest critic today, it can target the quiet teacher tomorrow. Vindictiveness doesn't stop at high-profile enemies. It trickles down. And once juries, judges, and citizens start assuming politics sits in the prosecutor's chair, even legitimate cases bleed out on the table. We need clean hands. We need bright lines. We need records preserved, decisions justified, and mistakes owned in daylight. So no, this isn't just about James Comey. It's about whether justice is a principle or a prop. If this case was built on pressure instead of proof, it should fall, and loudly, so the message is unmistakable. In a democracy, the law chases truth, not enemies. Hold your leaders to that. Demand receipts. Because if we trade accountability for vendetta, we won't need a strong man to kill democracy. We'll do it with a shrug.